Speaking of benefits, I'm Kevin Long with Employee Benefits Law Group, and today I'm joined by my partner Marcel Weiland. If you've discovered you've missed one or several Form 5500 filings, the fear is usually penalties, and that fear can lead to expensive delays. In this episode, we look at the DOL's Delinquent Filer Voluntary Compliance Program, or DFVC. We look at what it's designed to do, the biggest misconceptions plan sponsors have about late filings, and how multi-year caps can change the strategy, and when this needs immediate legal attention so that what could be a manageable correction doesn't become a bigger exposure. So, Marcel, taking into account your years and years of experience in dealing with these issues in the program, when a plan sponsor realizes they've missed the Form 5500 filings, so, in plain English, what is the DFVC program designed to do?
Well, Kevin, it's designed to guarantee that a plan sponsor doesn't have to pay penalties for the failure to timely file Form 5500s. It's cheap insurance because if they don't pay the smaller amount, they may have to pay a larger amount when the DOL or IRS comes knocking.
Yeah, you've described then the DFVC essentially as a relief valve um, for the pressure of not filing. And you talk about early handling it and big fees versus small. So, what's the single biggest misconception sponsors have about the late filing penalties?
Well, they might think to themselves, well, they can't be that bad, and they could quite possibly be that bad, or even worse than they think. So the maximum IRS penalty was recently increased to $150,000 per annual filing. And the DOL normally assesses about $50,000 per filing for late filings. However, I've seen the DOL assess a penalty of up to $270,000 for multiple years. So that's quite a
Oh,
significant
oh,
amount.
wow, ouch. So, when the plan sponsors discover several years of missed filings, how do the penalty caps change your strategic analysis and how you handle their entry into the program?
Well, since the per plan cap is a total of only $1,500 for a small plan and $4,000 for a large plan, there's less concern with the costs preventing a plan sponsor from buying penalty protection. They're more likely to file when they realize that the costs are quite not necessarily affordable, but they're a lot lower than the potential penalties that they would face. So they're not going to be having to pay a large penalty for each year. They only have to pay a cap of 1,500 or 4,000.
Right. Okay, so given the pressure and given the downside and the penalties, at what point do you tell a sponsor that this needs immediate legal attention rather than just internal cleanup?
Well, if the plan sponsors received a notice from either the IRS or the Department of Labor about a missing Form 5500, that's when I would say they would need immediate legal attention. This is especially the case if the plan sponsor receives a notice of intent to assess a penalty from the DOL, because at that point, they have 30 days to file a request for a hearing before an administrative law judge before the penalties become final. But even before they get a notice, I would say deal with it sooner, because in the old commercial, you can either pay me now or pay them later.
Hmm. Right, and I think in your experience, you haven't had many clients wind up dealing with an administrative law judge. That you've been successful in dealing with this directly with the Department of Labor and minimizing fees and getting things cleaned up. Is that about right?
That's right. I mean, when we have gone and had to file a request for a hearing before the administrative law judge, that's when the notice has been given. And then we negotiate with the Office of the Solicitor at the Department of Labor. So we are negotiating with the DOL's attorneys before it ever gets to an administrative law judge. And oftentimes at that point, we can negotiate the penalties down to like 5 or 10% of what they may have been. But we can fix things before it ever gets to that point in most circumstances. But even if you have to go to administrative law judge, we can negotiate those penalties down before we actually have a hearing.
Right. Yeah. So, given that entire context, um, your fees could be and your penalties could be very high. heaven forbid. So, in terms of paying those fees, why does it matter that DFVCs must be paid from employer assets rather than plan assets?
Well, it would be a breach of fiduciary duty for a plan sponsor to pay those fees from the plan assets. The DOL's position is, why should the participants' benefits be reduced because of the failure of the plan sponsor to file the 5500s on time?
Yeah. So I guess the bottom line is that DFBC uh, transforms what would be a potentially an existential compliance problem into a manageable correction if handled early and correctly. Great. Thanks for your comments, Marcel. If you need specific guidance on this topic, let's start a conversation. And now for the fine print. This podcast is for general informational purposes only. It does not create an attorney-client relationship between Employee Benefits Law Group and the listener or reader and does not constitute legal advice for a specific situation.